All right, welcome everybody. Today we are talking about employment law with Marina. She's an associate at Dorsey and Whitney. So today we're talking about a big topic, and we could probably spend the next month talking about it and still not touch everything we need to touch. And we've only got an hour, so we're gonna scratch the surface, and Marina's going to talk about some of the bigger issues that are causing problems in the employment world in Washington state. We have laws at the federal level, the state level, and even the local level. So this is just not only looking out for your people, but looking out for your firm, for your owners, and for yourself. If you manage people, if you're an owner, even a small owner, your risk is heightened. So it only takes one disgruntled employee to cause a lot of hot legal water for your firm. So today we're so excited for Marina. She is, as I mentioned, an associate, but you've also just going through your bio, you have quite the interesting history. But what I loved was that you're born and raised in Romania. So that was pretty cool to learn about you. I think what makes you unique is that you play both sides with the plaintiffs and the defendants. Litigation experience, breach of contract, non-competes. I mean, you name it, she's done it. So Marina, please take it away.
Thank you. Thank you so much. Thank you all for being here today, listening to me speak about this. I am actually, I'm really passionate about what I'll do. So I'll take a few minutes with some background. Thank you so much for that introduction. As Brittany mentioned, I'm an associate at Dorsey and Whitney in downtown Seattle. Before I was at Dorsey, I used to be at a plaintiff's firm, so I did a lot of employment work from the plaintiff side. And I am originally from Romania, and I bring that up just to kind of reiterate that my passion, because being from Romania, but what I mean by Romania is actually very, very rural Romania, as in I grew up without running water, with an outhouse. We raised our own, we raised chickens and pigs, and we grew our own vegetables, so that kind of thing. And so I am very, very fortunate and grateful to be here for the opportunities that my parents have given me to bring us here. And I guess I'm still not cynical yet, because I do think that what I do every day, I do help people, and people have told me that I sort of went to the dark side when I started representing employers, from the employee side going to the company side. Some people see that as going to the dark side, but I truly, genuinely believe that is not the case. I do think that I have the unique opportunity to help both employers and employees, being on the employer side, because everyone's best interest is to make sure employees are treated fairly and to make sure that the laws are complied with, and that way we can avoid conflict. And being on the employer side, I can kind of take a step back and write the story and be able to avoid a lawsuit. Whereas when I was on the plaintiff side, I would be brought in when there already is a problem and when an employee already wanted to find a lawyer. So I love being able to advise employers, give them the information they need so that we can hopefully not get there, and the employees feels as if they've been treated fairly and the company can avoid any disputes. So I'm passionate about that, and as part of that, I created this presentation to help kind of catch people, get people up to speed with some legal updates that have popped up in the last couple of years, because in the last couple of years, we've really focused on COVID, especially as employment lawyers. As you can imagine, we've been dealing with COVID-related questions at the beginning, furloughs, layoffs, COVID leave, vaccination policies, all of that. And while all of that was happening, there were some other legislative issues that have come up. So this presentation, now that COVID, we're kind of transitioning out of that, I thought it'd be good to present this topic, which has to do with legal updates that are unrelated to COVID. And kind of what else has been happening, what cases have come out of Washington courts, federal courts that affect Washington employers. So that's how we came up with this. And I want to, hopefully you find it helpful and relevant. So here's my contact information. Please feel free to reach out after this. If you have any questions, I'd be happy to answer, get more specific about kind of the topics I'm going over with today. As Brittany noted, it's going to be, general topics. I could talk about this for so long. I've already had to cut back the presentation. So if you have any follow-up questions, happy to engage and answer anything via phone, email, whatever it is, or during the presentation. Okay, so today here are the topics that I sort of chose to discuss. We're going to talk a little about wage and hour issues. Those are always really, really important because the penalties in Washington state for wage violations are very, very high. The state is very employee friendly, much more so than at the federal level. We're going to talk a little bit about exceptions to at-will employment. As you all probably are aware, Washington is an at-will employment state. However, there are certain exceptions to that. Always, it never means what you think it means, at-will employment. Then we're going to talk a little bit about arbitrations and the limitations around those types of clauses. Some case law about discrimination and some new legislation related to discrimination. And then I'm going to go over some helpful resources that are kind of my go-tos when I deal with some of these issues or employment-related issues. I'll also have some highlights throughout the presentation. I'll also have some resources throughout the presentation, and I'll highlight those once we get to them. I think that it's just, and some of them you might be aware of already, but some of them I like to share because some of my clients just hadn't realized that was an option. So here we go, talking about wage and hour. So kind of the most significant update are these really big changes to Washington state overtime pay rules and the minimum wage rules. So this started last year in January. And the minimum wage and the exempt salary thresholds have significantly increased, and they will continue to increase in the next at least 6 years. So the way that the salary thresholds are calculated, they are a multiplier of the minimum wage for a 40-hour week. So in the next 6 years, the minimum wage is going to increase and that multiplier will increase, which means a really significant increase for the salary exempt salary threshold. So by 2028, they estimate about 259,000 employees will be now eligible for overtime. So employees that now may be properly classified as exempt may not meet those exemption requirements in 2028. So more specifically for next year, the Washington minimum wage will be increasing as well as Seattle and CTAC. So really important to check local laws always. When you do have local laws, that means they're more employee friendly than the state laws, just like the state laws are a lot of times more employee friendly than the federal laws. And so LNI, they'll be making a cost of living adjustment slowly to the minimum wage. And then each year, the minimum wage will be announced in September, take effect the following year. So salaried exempt employees, they must earn a minimum salary established by a multiplier of the minimum wage. That's how it's done at the state level. So as the minimum wage increases, the salary threshold will increase. But as I noted, the multiplier will also increase. So again, it's going to be a very big jump for that salary threshold. For example, in 2022, to be exempt, an employee must earn at least about $53,000 a year. Comparing that to the state threshold, or sorry, the federal threshold, that is a big jump. It's almost a double, almost, not quite. But for example, if you had an employee in a different state that wasn't Washington, that employee might be properly classified as exempt, but an employee Washington having the exact same duties, the exact same job as someone outside of Washington might not be classified as exempt, might be improperly classified as exempt because their salary does not meet this higher threshold. So there's an implementation schedule. You can find this online. It's in the materials, and it has sort of each year what they estimate the increases will be, and for small and large employers. But as you can see here, and it might be too small to see, but you'll get these materials. In 2028, the threshold is going to be 85,000. So meaning no one, making under that amount will be able to be classified as exempt, which is again about 50,000 more than the federal threshold. So it's quite significant. It's important to pay attention each year. 1 year the employee might be properly classified. Next year, you'll need to make some changes. So changes that companies should make. So always analyze, each year if the employee meets the salary threshold and the job duties. And remember that it's the job duties that matter, not the title. So for example, if you have 2 supervisors, you might just classify them both as exempt because they might meet the executive exemption requirements. However, if one of those supervisors has only one direct report, and then the other supervisor is supervising a department of 10 people, well, then that supervisor might meet the requirements of the exemption because the exemption requires a supervisor to regularly supervise at least 2 employees, whereas somebody that only supervises 1 employee, that might not meet the requirement. So it's always important to look at the actual duties, not the titles, to see if they're properly classified. And if the salaries increase and you need to make a decision about whether to reclassify that employee or to just increase that employee's salary so it meets the threshold, I always recommend really evaluating and looking for what are the different options. You could reclassify them as non-exempt, and then in that case, they would be paid for overtime. But if that employee, for example, doesn't work a lot over 40 hours, then that's what you might want to do. If the employee often works over 40 hours, then you might want to just increase their salary so it meets the threshold, because then you wouldn't be responsible for paying overtime. So it kind of depends on that particular employee, how much they work and what their job duties are. And remember always that reclassification may result in additional changes to the terms. So it's really important to always keep in mind, especially in Washington State, rest and meal break requirements. Washington State employers have a very high burden to ensure that their employees are taking their meal and rest break periods, not just to provide them with the information. And so that's a pretty high standard, and exempt employees don't have that requirement. So if you reclassify someone as non-exempt, that will have to be taken into account. And then paid sick leave too. Exempt employees are exempt from the state sick leave requirements. Seattle, however, sick leave law does apply to both exempt and non-exempt. So that's why, again, it's just important to check in on those additional requirements for non-exempt employees. And kind of outside the scope of this presentation, because this is a little bit related to COVID, but I don't think that it's necessarily related to COVID because it's just kind of the new norm, teleworking. I always like to bring this up when I talk about wage and hour issues, because employers sometimes forget that you have remote employees, they might be non-exempt. The employer must still ensure compliance with those meal and rest break periods. And so I think that it's important to check VPN, check online, activity, check kind of have them track via an app. So all types of things where employers can check the activity and ensure that break compliance. And this is one of those resources I mentioned. This is a great article that talks about just kind of flags the issues for remote employers related to wage and hour, remote employees related to wage and hour, but also tax issues and any other issues that might come up when there are remote employees. Okay, so Brittany, I think there are some questions. Do we want to stop or do we want to wait till the end, or how do you think we should go about that?
Yeah, I'm watching the chat box. So if you're okay with just kind of in between and we just kind of give a couple minutes and kind of go at that rate, I think that works.
Okay, should we, okay, Great. That sounds good. So yeah, let me see. Oh, and I think I saw a hand up too. Sorry, is there still a hand up?
Um,
I can.
Okay, I can go through the chat. Let's see.
I can go through it. You're doing all the hard work, so I'll read them for you.
Okay, okay.
So Stacy
Okay.
had a question and she says, it's a federal minimum salary for exempt prorated for part-time employee.
Yeah, so it depends on, yes, exactly. So it depends on a full-time or a part-time employee, and those there are different rules, yeah, for those.
Awesome. Stacy, did that answer your question? Looking like, yep, okay. Then the next one, 85K minimum for exempt is for the year 2023 or 6 years from now. And I think Sarah Davis said 2028, right?
Yeah, that's correct. That's correct.
Perfect. And it looks like one more, and it was from Evie, and she says, for exempt employees, employer does not need to document rest meal on a timesheet, for example, question mark. So do we need to be documenting it on timesheets, or kind of, do you have best practice to document it?
Yeah, so there's no requirement for exempt employees to really track their rest and meal break, or their exact hours on a timesheet. However, I think that it's always, if there's a way to at least get a sense of how many hours the exempt employees are working, because that's how you make those decisions, like I discussed, about whether to reclassify them. So it's good, if they have a supervisor or anybody that can kind of tell you, well, about how many hours on average does this person work per week? Because if it does become an issue and you do have a misclassification issue, if that person should have been classified as non-exempt, or you want to classify them as non-exempt, it's good to know about how many hours they're working so that you can decide, how much they're owed, if anything.
Awesome. Evie said very helpful. Thank you. One last question. Non-exempt are required to record their breaks, question mark.
Yeah, that's a really good question. So for ideally, what you would want would be, yes, some sort of app or something, a way to track their breaks. Of course, they're not clocking in and out for these breaks, the rest breaks, because they're paid. But I think it's always helpful, ideally, to have something where they say, okay, here I am taking my break, and then, okay, I'm done taking my break. Of course, that can be sometimes an administrative burden, and employers don't always have those applications in place. So something else that I like to recommend is, at the end of the day or at the end of the week or something, there's some sort of attestation for the employees saying, I acknowledge that I took all my breaks, and if I didn't take my break, I notified my employer, or my supervisor, and they were able to they were able to compensate me for that time, or something like that, so that if this does come up, you have evidence to show that the company has taken steps to ensure that the breaks are taken. It's a pretty high burden, so the more documentation you have, the better.
That's an amazing idea. I love that. Are you able to give any kind of insight from what you've seen on like fines, even just like first time offenders, and like if you were to get audited, and just kind of like the weight of fines and fees and back taxes and kind of impact?
Yeah, I mean, the biggest issue when it comes to wages is that everything, so employees can ask for not only double wages, because under Washington state, there are penalties, so they get double wages, but they get all their attorney's fees as well. So when I was at my previous firm, I represented a plaintiff where I think he was only really owed, I don't know, like, I want to say only like 8,000 in wages. And we really went to trial because we could not settle it. We went to trial, and the jury ruled in our favor. So really, he ended up getting 16,000, but also about 100 grand in attorney's fees. Yeah, which it was, quite significant, considering, of course, attorney's fees can be much higher, but that's significant considering it was only, obviously it's a very contentious matter. That's why I went all the way to trial. But that's, those are the rules. So it's really important, the attorney's fees provision, even if it's just a little bit. And of course, then if you get into class actions, because this does happen a lot of times, on a class action level, then it's they're much more significant penalties and much more significant attorney's fees.
Oh my gosh.
Yeah.
What policy would this fall under for everybody who's dealing with the insurance and just making sure that we've got the right coverage?
Yeah, that's a really good point. Yeah, I mean, I would just contact your broker. You never know where this falls under, business, insure, anything like that. You never, in different ones, it's property. So it really kind of depends on your carrier. And so I always recommend definitely contact them, definitely make sure you're covered. And you kind of never know. Yeah, it just depends on the different policies. I've seen it different ways. I think somebody recommended I even personally check with my it was like renter's insurance years ago and see what we can get under there. So you just never know, actually.
Amazing. Good input. Thank you.
Yeah.
Any more questions before we move on to the next section? All right, I think we're good. Thank you.
Okay, great. So next is still a wage and hour issue. Just wanted to flag a little bit different from the federal law. Again, it's compensable time. So as you all know, all employees must be paid minimum wage for all hours worked as defined under state law. So that includes trainings, meetings, closing and opening a business, logging in, things like that. There was a recent case last year where the court decided that employees traveling to and from China, all that travel time was compensable. And so this is very different from the federal law. Under federal law, if you have an employee that travels to a different city, state, and stays there overnight, they would be paid for their normal business working hours. So 9 to 5 or whatever that would be. And if they're traveling in that time, that would be paid, but not outside of that. And so here, in this case, the court actually concluded that all the travel time was compensable. So very different from federal law. So when, I always err on the side of if they're asking for the payment, might as well just pay those wages. It's worth it, considering the severe penalties that I discussed if, there's any sort of issues there. And then just quickly, Washington hasn't adopted the federal de minimis rule. Under the federal rules, the de minimis doctrine states that if there are sort of de minimis tasks which are done kind of irregularly or once in a while, and it only takes a few minutes here and there, those are not compensable. However, Washington in this case, they noted that those tasks could be considered compensable, and Washington has not adopted the federal doctrine. So simply because something is what's called de minimis doesn't make it not compensable time. And so be aware of, if you have employees that have to log in and be, sitting at their desks and logged into their computer at a certain hour, did they have any mandatory tasks that they had to do before then? That might be considered compensable under Washington state law, whereas it might not be compensable under federal law. So that's this case here. And so now moving to exceptions to at-will employment. So Washington is an at-will state. There are certain exceptions, such as, for example, you cannot terminate someone based on discrimination or retaliation, or public policy concerns such as whistleblower, if they reported some sort of safety issue or anything like that. And so I would like to talk about one that's implied contract, which it never really comes, it doesn't come to my mind. And so it was an interesting case. So I wanted to share it. This is a case against the Bill and Melinda Gates Foundation. It was filed by a plaintiff. He quit his employment to accept an offer as the first chief digital officer of the Bill and Melinda Gates Foundation. He was an at-will employee, but he got terminated for performance issues. So he filed a case against the company saying that they breached the promise to provide him with that position. And the court found in his favor, surprisingly. So the court noted that the foundation itself spent months trying to recruit him. He bargained for the specific position, but he was pushed to focus on IT duties. So he was terminated after 18 months. And the court noted that while there isn't an implied duty of good faith and fair dealing in terminating the contract itself, there was a specific promise for a specific role, and the employer breached that duty by not providing that position that they promised. So while the company could sort of modify the responsibilities, they couldn't fundamentally change what it meant to be a chief digital officer. And so what that means for employers generally is to ensure that the job description is accurate description representation of the actual job. So review these each year, review these job descriptions, because like I mentioned, different jobs, it could have the same job title, those could include different duties. And so those descriptions should reflect the duties of that particular position. So review those annually and review them with the employees to make sure they understand exactly what they're signing up for. Of course, include the disclaimers saying that it's not intended to be comprehensive, and then don't use overly aspirational language. So, this was the first chief digital officer, which was supposed to be some prestigious position, and then it ended up not being that. So it's always important to make sure you're not entering into these contracts and having the ability to change the duties. Okay, and I did want to know, so someone posted that has been an updated salary schedule. I did want to mention that is a great point, and I'm not sure when this was last updated, when that schedule was entered into this presentation, but that means it's going to be changing. And so this is not a schedule that, I wouldn't be surprised if next year is going to change again. And so each year, make sure you're checking what the minimum salary thresholds are, because I expect these to go up each year, because they don't know how the minimum wage is going to be raised each year. They know how the multiplier will be raised, but they don't know how the minimum wage is going to be raised yet. So those are just estimates. So each year, I'm sure that schedule is going to change. So now arbitration provisions. These are really important to include in your employment contracts if you want to include them, because you can avoid a class action, you can have faster resolution, and sometimes less expensive resolution. But they're not always enforceable. So in this case, I see this happen a lot. So it was an arbitration agreement that was actually signed with the parent company and not the employee's employer. So for example, I have a lot of clients in Canada that have a parent company in Canada, and then they have a subsidiary in the US, and that subsidiary is the actual employee or employer of the US employees. But they're using the same contracts, so they use contracts where the employer is actually the Canadian company in the contract. So in this case, the court ruled that an agreement to arbitrate with the employer's parent company is not enforceable, because the employee did not agree to arbitrate disputes with its employer. It agreed to arbitrate disputes with its employer's parent, and there's no relationship between the employee and the employer's parent. And so the takeaway here is just to be incredibly careful when you're drafting these contracts and giving them to employees. Try not to use form contracts, and check to make sure that it's the accurate employer on each of these agreements, so that your arbitration clauses are enforceable. That's this case. Okay, so here is an interesting case, and I think it comes up a lot. This has to do with arbitration provisions and employee handbook. So this is a case filed by a former employee of Pagliacci. He brought some wage claims against the employer, and the employer moved to compel arbitration, but the trial court denied the employer's motion. The Court of Appeals affirmed that, and this went up all the way to the Washington Supreme Court, who affirmed the decision to not enforce the arbitration agreement. And here's why. So during this person's onboarding, Pagliacci gave him several forms to sign, and kind of told him, hey, get through these, sign these so that you could start your shift. And so one of the documents that he signed essentially incorporated by reference the employee handbook. So it said, that he agrees to all the terms in the employee handbook. And so in that case, the employee handbook itself contained an arbitration provision, but the arbitration provision wasn't referenced in any of the forms he signed, and the arbitration provision wasn't in the table of contents in the handbook. He was given the handbook, but told to read it later. And the arbitration, not only that, but the arbitration policy itself mandated some sort of pre-arbitration conciliation process that didn't hold the statute of limitations. So that's very pro employer because it kind of shortens the statute of limitations essentially. And so the court decided that the employee did not agree to the arbitration provision. He wasn't even aware of it when he signed these forms. And not only that, but the arbitration provision itself was unconscionable because of this sort of pre-arbitration conciliation process. And again, it went up to the Supreme Court, and the Supreme Court agreed. It did not exist because he did not have an opportunity to understand it when he was hired. And even if it did exist, it was unconscionable, both in the procedure, again, that's because he didn't get a chance to read it, but also the substance of it, because it had that pre-arbitration investigation process, which shortened the statute of limitations. And so I'll go over this again in a little bit, but I strongly recommend having those arbitration provisions front and center in the agreement, making sure that the employee is aware of them and signs off saying that they've agreed to the arbitration provision, not in some other form that it exists that they weren't aware of when they agreed to it. Okay.
We've got a couple questions in the chat box.
Mm-hmm.
So going back a little bit, but somebody asked, what if job descriptions are vague? I'm guessing like, what are the consequences and potential issues with that?
Yeah, I mean, that's kind of, it can go both ways. So vagueness always kind of opens the door for conflict, or a lot of times, I should never say always or anything, but a lot of times there can be issues come up because then there's a misunderstanding about what the job duties are. So then a lot of times I see employees saying, hey, this is not what I signed up for, and not necessarily that it's a breach of implied duty as we discussed, but maybe it comes with them not doing a good job because they weren't aware of what they signed up for, and then the employee's upset about that because they didn't get the right information and they didn't know what the job was. So even if it's not necessarily unlawful, to have a broad description or a vague description, I think that it could cause maybe some more back and forth because any sort of uncertainty could lead to, even if ultimately you prevail, if the employee does decide to, oh, you know what, I'm gonna, which is very unlikely that someone's gonna say, oh, I'm going to sue for breach of contract, especially if it's not, a high level position. But I think that what could happen is if any sort of gaps in the contract could lead to more back and forth and more questions and upset employees, which again might not be unlawful in and of itself, but that's how these disputes come up. Even if there is no unlawful action, if employees are upset and they think they're being treated unfairly, even if it's not unlawful, that's when you have to deal with this, and you just want to avoid it if you can.
Awesome, that's great. And then Sarah Davies was asking, she says, can job descriptions be changed when no longer qualified to make somebody, or I guess maybe when making somebody no longer qualified for a job position?
Yeah, and that usually happens when there's some sort of company either restructuring or there's sort of a new role that needs to be filled. And so that can sometimes lead, like I've had it be where, for example, an assistant what needed to be had certain qualifications, but then the person, their supervisor got promoted, and now there were additional skills that were needed for that person's assistant, and so the job description needed to be changed, and maybe that initial person couldn't meet those, were no longer qualified, and so that can happen, and it sort of depends. Employers have options whether it depends whether they can train the person, whether they can give them the option to train or the option to at least apply for the position, or it might just be, you know, a layoff or a separation of employment, or if there's a different role, maybe they could find a different role. But that does sometimes happen when there's some sort of restructuring in the company and there are changes.
Awesome. That's a really good answer. And I have one quick question. So do you have any best practices for like onboarding new employees? And you know, you've got this massive manual. I love how you say like put the most important in the front, but is there also like a process where we've started recording ours, and then like we have a recording and we just kind of hit each section and then let the new employee listen to the recordings? And so do you have anything helpful for everybody just to make sure like the most important ones are, they can't dispute they were never told it?
Yeah. So definitely, of course, you know, some policies are more important than others, like you said. And so anything that's really important, like, of course, if you have some, you know, confidentiality provisions, have those in a separate agreement. Arbitration, have that, you know, in a separate agreement. And then in terms of the handbook itself, you have a giant handbook, you know, even just having them, you know, say, okay, take it home, read it, and then, or they could read it right there. Depends how big it is, but you know, it could be take it home, read it, and then sign this acknowledgement form that you read the handbook itself, you know, and then begin working. The problem here was that there was a form that said, oh, you know, I agree to all the terms of the handbook, and literally that person didn't get a they just were given the handbook and then they started working. So there was no way that that person had read or, you know, was aware. And definitely, you know, have it at least be also in the table of contents if it's something really important, and maybe I always recommend, hey, we're going to sit here, we're going to go over this manual and just point some things out. So in this case, you know, if Pagliacci would have been able to get a declaration from the supervisor saying, no, I went over this with him, we don't have anything signed, but during the onboarding, I went over and pointed out all these provisions. That can help, certainly. And then the other note that I always have with arbitration provisions in particular, because there's a lot of litigation about those, is even if they're in your employment contract, they're bold, I always like to have just like a separate section, like a line where the employee can say, you know, I initial here to agree to this particular clause, to agree to arbitrate. And I also know that I have the option to cross out this section. So that employee knows that that provision, you can cross it out. Yeah. So, you know, that's a good argument to say, this employee agreed to it. It's not a form agreement where it's take it or leave it. They could have crossed it out, but here they are initialing agreeing to the arbitration. So I always recommend doing that.
Super smart. Thank you.
Okay. Okay, and then another kind of best practice when it comes to arbitration, if you do have an arbitration agreement somewhere, don't participate in the litigation. In this case, the employer participated in the litigation, filed motions, took depositions, and then asked the court to compel arbitration. The court said that they waived their right to arbitrate by participating in the litigation. So for arbitration takeaways, don't wait to compel it. The agreement to arbitration should be clear, conspicuous, voluntary, make sure it's mutual. Both parties have to take their claims to arbitration and signed by the appropriate parties, the appropriate employer, not an affiliate. And so discrimination, these ones are always kind of close to my heart because, you know, as a plaintiff's attorney, I was always looking for good cases. Most of the cases we took on were on a contingency fee basis. So you always wanted to have a good case where you have a high chance of collecting damages. And so one of those always you know, if we had a timing issue, that would always be a good case for us as a plaintiff attorney. So if you have some sort of adverse action taken right after protected activity, that's a great case for a plaintiff. So you know, you want to avoid that. And here's a case that kind of demonstrates it. Here, there was a plaintiff filing a lawsuit saying that she was fired right after she became pregnant, and that her termination was based on her pregnancy. So sex discrimination. So here is kind of showing the timing a little bit. She was hired in May. She told supervisor about a pregnancy in December, and then she was fired on, the following March for failing at the PIP. But it was 5 days before the PIP completion date. I don't know why they couldn't just wait those 5 days. I always say kind of generally, if you have any sort of problem employee that has poor performance, not only is it important to make sure you're documenting the poor performance and even internal communications about the poor performance, always important because that can come up, even if it's not, communicated straight to the employee. But also, wait, sometimes you want to, if somebody says I'm pregnant, you're already planning to terminate them. I would just wait. I mean, pregnancy is kind of a long one, but someone that's a poor performer usually gives you another reason to terminate them later down the line. So if you're able to kind of wait to distance yourself from whatever that protected activity was, I always recommend doing that if possible. Some clients say, no, this person is such a risk to the business that I'd rather take the risk of her filing suit than the risk of some damage to a client that she may cause. And that's a different story, but you want to be able to weigh those risks. So in this case, this employee was getting feedback that she was showing progress, she was meeting expectations, and then she was terminated. Apparently, the PIP came one day after she discussed maternity leave options with human resources, and then some manager made a comment that this employee's supervisor was just, oh, poor Jen, who was the supervisor who was dealing with all these pregnant people. So obviously, be careful, don't make comments like this. And of course, really pay attention to timing issues. If there's any sort of complaint, be careful that it's not retaliation. If there's any, if they come back from maternity leave and then you terminate them right away. So anyway, there are just these things to keep in mind. And like I said, try to get some distance between the adverse action and the protected activity. And then for this one, I thought it was interesting, and the lesson is that some things might not constitute discrimination, but still not recommended. It's pretty common sense. There were 2 employees that worked for the same supervisor, and one of the employees happened to be that supervisor's, partner or fiance, or they had some long-term relationship. And so when there was lack of funding, the other employee was terminated. And they filed suit saying that they were discriminated against because there was favoritism towards the other employee. But the court actually held that, singling out that supervisor's partner actually is not discrimination, because the motive behind the termination is not the fact that that person was discriminated against because he was male, but it was because the other person was favored because not because she was a woman, but because she had the special relationship with the supervisor. Nonetheless, the court definitely warned against such activity. It's unfair, it's going to harm morale, and it's going to upset people. And like I said, sometimes the best advice is just be respectful, be kind to these employees. Sometimes them just getting upset is going to cause a dispute, even if there isn't necessarily a lawful activity. You just don't want to deal with it. You want to avoid it. So, I don't recommend something like this, but it's not discrimination, which I thought was interesting. And this is general federal law that you're probably all aware of. It might change. States have already issued some opinions that limit this ruling. This is at the Supreme Court. They noted that Title VII also prohibits discriminations against homosexual and transgender employees. Some details about the opinion. The discriminating on the basis of homosexuality or transgender status means discrimination because of their sex, which is part of the language of Title VII. But of course, we have dissenting opinions saying that, because of sex didn't include homosexual transgender status, because the people that drafted this wouldn't understand that phrase to include those groups. So just in general, I always say employers should ensure that their policies include protections for transgender and homosexuals. So just based on sexual orientation, gender identity, you want to include that in your anti-discrimination policies. And like I said, there are already lawsuits limiting this decision. of course, in Washington State, our state law does include sexual orientation and gender identity. And here's something from the Human Rights Commission. This link is really helpful. It's kind of like a manual about specifically this type of discrimination and some more specific questions. And it's great that they issued this, and I always recommend reviewing this if you're encountering these types of issues. Okay, this is kind of like a procedural ruling, but I think it's important to note that different laws have different, always covered different types of employers, different types of employees. So whenever you're dealing with claims or accusations, federal or local discrimination types based on disability, age, other protected classes, check the actual law and see if it applies to the employer and then if it applies to the employee. So for example, here, there was an employee who sued his employer for disability discrimination under the Americans with Disability Act. After the employer discharged the employee, however, the employer found some after acquired evidence showing that that employee actually wasn't qualified for that position because they didn't have a bachelor's degree in English. And so that, even though that decision may have been discriminatory to terminate them, actually that employee wasn't qualified at all for that position. And the court ruled that the ADA limits its protection to qualified individuals. So that individual couldn't sue under the ADA because he wasn't protected. Now that's different, for example, from the ADEA. This is an older case, but I just included it just to show that when you're looking at age discrimination, it's different. That is not limited to qualified individuals. So it's just always important to check those laws and see who it protects and which employers and employees are covered. Okay, and then real quick, something that employers don't know is that sometimes an employer can be liable for responding the way they will respond to a third party's conduct. So for example, here there was an employee that was working as a manicurist at the Wynn in Las Vegas, and they were sexually propositioned by a customer. He reported the incident to the manager, but the manager just told him to finish the pedicure, and his female coworkers kind of just stated that he should take that as a compliment. So he finished the manicure, but he was just uncomfortable, or sorry, the pedicure, but he was just uncomfortable. The customer kept making, inappropriate sexual comments. So he filed a hostile work environment complaint. And then the Ninth Circuit concluded that reasonable jurors could decide that the manager condoned this behavior and conveyed that sexual harassment would be tolerated because she took no action to stop it, didn't tell the customer to leave, and didn't protect the employee in any way. So while employers are generally not liable for harassment or inappropriate conduct by third parties, they can be liable with how they react to it. So whenever an employee reports any sort of customer harassment, the employer should investigate and protect the employee from further harm on that. This is really similar, so I'll kind of go quickly through it. It's a similar incident that occurred at a bank where we had a bank customer that was sort of stalking this other employee. And part of the stalking was actually the customer going to other banks and asking about this employee. And the court essentially said that all of that should be viewed together. All of those incidents should be evaluated together, even if they occurred over time, and then even if they occurred not directly with the employee, but with other branches, those should still be evaluated as part of that hostile work environment claim. And then this is kind of a big one that is very, very recent, has to do with everyone kind of updating their agreements. So back in 2018, as sort of part of the Me Too movement, lots of states issued these laws that prohibited non-disclosure agreements that prevent employees from sharing details of sexual harassment or sexual assault. So very recently in June, Washington really expanded the scope of these prohibited non-disclosure provisions. So as part of this new law, employers are prohibited from even requesting that a worker sign an agreement with provisions that would bar the worker from disclosing any sort of conduct related to illegal discrimination, illegal harassment, illegal retaliation, wage and hour violation, sexual assault, or anything that is recognized as against a clear mandate of public policy. So that is very, very, very broad. And the act applies to all agreements with employees and independent contractors. That includes severance agreements, settlement agreements, all of that. And so it's very, very broad. The only exceptions are that it doesn't restrict the ability for the employer to ask that the amount of a settlement or severance agreement be confidential. So the amount of the money that is paid in exchange for the release of claims. And it doesn't, of course, prohibit an employer from protecting its trade secrets and confidential information. The act is also retroactive. So it invalidates any sort of non-disclosure, non-disparagement provisions before the effective date, except for settlement and severance agreements. But employees can't recover damages for those agreements that are already in place unless the employer tries to enforce those agreements. So if you have agreements signed before that date, I would discourage you from trying to enforce those provisions that might be unlawful under the rule, because there are severe penalties. There, again, it's a violation to even request that employee signs these now, and for retroactive agreements to attempt to enforce them if they're non-compliant. And the penalties are high. Employees can ask for actual damages or statutory damages of $10,000 plus attorney's fees. Again, attorney's fees is a really, really big one. So I strongly recommend going through any sort of non-disparagement. Those are always a problem, or non-disclosure, just to make sure that they're very narrow, or that there's some sort of carve out for the illegal conduct specifically provided for in this rule, to make sure that employees can speak up on those. So just discrimination takeaways, just a quick summary. Again, beware of timing, beware of that protective activity and any adverse action you might want to take. Give yourself some room if you can. Just because something isn't unlawful doesn't make it advisable. Again, be kind, be respectful. This is relating to that case about the supervisor's relationship with that employee. Protected classes have expanded. They include transgender homosexual employees. Certain laws, not all, limit the protection to qualified individuals. The company may be liable for reactions to third-party conduct, so not just its employees, not just its managers, but third party, the way they react to the third party, and avoid broad confidentiality provisions. And so just real quick then, last kind of substantive slide here, the resources, the biggest one, so in addition to the two I mentioned, but the biggest one that I always recommend is the Job Accommodation Network. You might be familiar with the askjan.org. This is kind of outside the scope of this, but whenever I am evaluating reasonable accommodations or advise on the interactive process, askjan.org is amazing. Not only does it have articles that are very specific to the topics that employers are searching, but they have this great drop down menu where you can really pick sort of any condition. For example, a couple of weeks ago, I was looking at migraines, employee migraines. So you pick migraines, and then it tells you, what information do you need? What causes the migraines? What information can you request from the employee? What accommodations you can request? And it has a lot of creative options depending on the type of migraine, whether it's considered a disability. Yeah, so it's really, really, really useful. And then I have the blog, that's our blog, but we really do, sometimes I'm just Googling questions and our blog comes up. This is our employment law blog. I just wrote an article on it. We actively update it. It has very specific answers to specific questions. And then last, I'm sorry, I'm talking really, really fast. I know, just trying to get through it.
So good. You're doing so good.
This is the link to administrative policies in Washington. It's not, I'm sure you're all aware of these, but I do sometimes send them to my clients, and they are not aware of these sometimes, because, we have our statutes and we have our regulations, and they just have so many gaps, I think, and a lot of it is uncertain. And so a lot of times I just go to the relevant administrative policy, and it just has so much more context and so much more guidance. And so I just provide a link to it just in case you're not aware. There's a lot there that can really fill in the gaps in those laws. So, okay. There we go. We have 4 minutes. I spoke really fast. Okay.
You did amazing in the final quarter. So for anybody who needs to hop off soon, I totally get it. And Marina, if you've got a couple minutes to hang on for anybody who has questions, getting some feedback in the chat box about great resources. So thank you. And I think Evie had one question or comment. She says, comment shows that the workplace was hostile to maternity or parental leaves. Yes, comment shows. So Evie, can you provide a little more clarification on that one?
I was just thinking about how I could see a manager making that like, oh, wow, comment, and maybe not understanding how it's portraying the workplace, and just needing to like prepare managers ahead of time and help them filter what might be a gut reaction. And what I always say to my people is that we're always at an at-will employment situation. Someone could leave at any time. So let's not highlight this protected activity when this could happen because they just win the lottery next month.
Yes, and it's a great point, especially when it comes to managers and kind of and sometimes I know it's, I'm talking maybe to the HR person and they have to do, with the manager, and the manager has they're working with that person directly, so they are more inclined to terminate or say something because they just have more contact. Me as a third party, I can kind of advise on what managers should do, and that's why it is important to communicate all of that down the line, but it's a lot easier for a manager to say something or do something without I have this training that I do for managers, and the main message is contact HR whenever there's a question. Just contact HR, get HR involved whenever you may even think there's a question. And a lot of times they don't, because a lot of times they just respond to the work, but maybe they don't think about, oh, hey, this person's also pregnant, or maybe this person has a disability, so I need to take a step back and make sure I'm aware of all that before, and obviously you should never make comments like that, but you don't think about that stuff. Maybe you're just talking at the water cooler with somebody, I don't know, and you say something, and then that evidence all together plus the timing that suggests that maybe that person was terminated because she was so difficult to deal with because she was pregnant, and they say, oh wow, they're having such a hard time managing this person.
I love that you mentioned that, because one of the things we do, and we started doing a couple of years back because we operate in California too, and they require the sexual harassment and discrimination training every 2 years. So we've made it a trickle effect in our Washington firm for the employees. And so if anybody wanted to reach out, you said you provide training to managers. So that's something that maybe you could help kind of get the ball rolling on. Okay.
Yeah, exactly. And yeah, I'm actually preparing one for California, specific one next week. Yeah, for the new HR business partners that one of our clients is hiring. But we also do one that's called Managing Within the Law. So we assist a manager kind of, because you got to look for all the red flags, at least be able to notice them. And maybe you need some maybe you need some help, some HR help to kind of work through them, but at least to notice them and to know what issues to spot, just to be aware. It's good. Yeah, you can avoid a lot of issues, but let me tell you. Yeah.
Yeah, and I saw you also review employee manuals, so you use Marina as a resource if you guys have questions, and see if you need help with something. Basically do it all. So
yeah, happy to look through those handbooks, through those employment agreements, confidentiality provisions, or arbitration provisions, things like that. Yeah, definitely.
Beautiful. Well, it is 1 p.m. on the dot. So anybody else have some burning questions? All right. Well, I think that is all. Everyone says great job and thank you and amazing. So thank you again for your time. It was fun.
Good. Yeah, it was great to be here. Thank you so much for the invitation. I really appreciate it.
Thanks, Carrie, for the connection. And
Yes.
hopefully see you guys in November for our succession planning event, and have a good rest of your week. And I'm going to stop the recording. Thank you guys.
Thank you.
Bye, Marina.
Bye-bye.